Welcome to Contracts. I'm Professor Diane Sullivan, and I teach contracts at the Massachusetts School of Law. Now, we're going to spend roughly the next 4 hours reviewing, as an introduction, the law of contracts. The textbook I use right now in class is called Studies in Contract Law, the 5th edition. It's a university casebook series. The authors are Murphy, Spidell, and Ayers. You can, however, use this lecture to go along with any textbook. Now, let me tell you why I'm telling you about the text. I have organized my lecture in accordance with the sections in the textbook because I like the way it's organized. The first section is the basis for promissory liability. And we're going to begin our review today talking about consideration and then an alternative for consideration, which is known as promissory estoppel. Our next topic, or our next section, will deal with the formalities in contracts. When do you need a writing? That is called the Statute of Frauds. From there, we will talk about the agreement process, offer, acceptance, and then take a look at when there is defective formulation or there are indefinite agreements. Our next section is avoidance of contracts. We will look at things like incapacity, meaning infancy, mental incompetency. We'll take a look at what happens when there's a mistake, fraud, the duty to disclose, duress, unconscionability, and illegality. Our next topic is Section 5, and that's the scope of a contract and the extent of obligation. We'll look at the parole evidence rule, and I might tell you you're going to struggle with the parole evidence rule. We'll take a look next at conditions. When circumstances change, there are things called impossibility, impracticability, and frustration of purpose. And we'll also take a look at the duty of good faith in all contracts. Our next section is Section 6, and that deals with damages and remedies, and we'll do that at an introductory level. And finally, we'll wrap up with Section number 7, which are third-party interests, assignment and delegation, and third-party beneficiaries to contracts. So again, I welcome you to this review on contracts. Let's begin. Let's start with the definition of a contract. The most common definition of a contract is simply a promise that the law will enforce. The key elements of a contract are mutual assent, consideration, and of course, the parties must have legal capacity, and there must be a legal objective, or there cannot be a prohibition by law on whatever the subject matter of the contract is. Now, before we begin with consideration, I want to take a few moments and I want to define for you what we mean by an express contract, what's an implied contract, and let's talk about quasi-contracts, and then we'll begin with today's lecture. Okay. The agreement, and what we call in contracts the mutual assent of the parties, provides the basis for formation of a contract. And if it is done by words, we call that an express contract. When the agreement, on the other hand, is formed by virtue of conduct as opposed to express words, then we call this an implied contract. So you'll see those terms used throughout your study in contracts. Now, whether the contract is express or whether it is an implied contract does not affect in any way the legal relationship of the parties. And the rules that govern contract apply regardless. The primary characteristic of a contract, whether it's express or whether it's implied, is that the law is going to enforce that promise or those set of promises. This is usually done by granting the benefit of the bargain. If I enter into a contract, what did I expect to get? And I ought to get that benefit. Now, one other definitional thing before we begin, and that's a quasi-contract. A quasi-contract, or as they're sometimes called, contracts implied in law, are not true contracts at all. They do not depend on assent between the parties because there isn't any. In a quasi-contract, the law imposes the obligation because it's the right thing to do. It is just. So since the defendant typically has not made a promise in cases seeking quasi-contractual relief, the law does not enforce the promise. It simply makes restitution, has the defendant pay restitution. So those are some basics that you need to know about, and let's begin our study of contracts. I like to start with consideration. Consideration is a good beginning point to study contracts. So let's define consideration. Consideration is bargained for legal detriment. Once again, consideration, good definition, bargained for legal detriment. The legal detriment is the thing. It is what is given for the promise. The other aspect of consideration is bargain. It's the process. So the two aspects, once again, are the thing exchanged and the process. Legal detriment, bargain. Remember those two terms. Now, when we are talking about legal detriment, the legal detriment aspect of consideration, what we're referring to is the promisee giving or doing one of the following. The promisee must either, one, do an act, or the promisee must promise to do an act, or the promisee must forbear from doing an act, or there must be a promise to forbear. Those are your four aspects of the legal detriment side of consideration. You must find one of the following four for you to find consideration. Now, when we're looking at consideration, you have to be sure that there is sufficient consideration to support the promise. Do not get that confused with the adequacy of consideration. Law students sometimes, and the general public sometimes think that we have to look into the size of the consideration. Was the consideration adequate to support the promise? Courts do not look into the adequacy of consideration. They do make sure there is sufficient consideration, that it was actually bargained for in exchange, but they don't look at the size. If I sell you my watch, and my watch is valued at $1,000, and I sell that to you for $200, the court does not care that you only paid $200 as long as it's not unconscionable or as long as it's not a disguised gift. But the courts do not inquire into the adequacy of consideration. It should not be worthless consideration or sham consideration or unconscionable, but short of that, the court does not care about the adequacy of the consideration. Another important note, it is not necessary that the promisor actually derive any benefit from the promise or from the act. That is not a necessary aspect of consideration. So the courts will enforce promises even if the promisor receives no benefit from their promise. A leading case, it's called Hammer versus Sidway, a very old case, I think it was 1891 or so that it was decided, in which an uncle promises his nephew, if his nephew refrains from drinking, gambling, smoking tobacco, chasing women, and so forth until he's age 21, the uncle will pay him a certain amount of money. And the question before the court became, gee, is the promise enforceable because the uncle didn't benefit in any way? The answer is yes, it is. There need be no benefit to the promisor. Next thing I'd like to take a look at under the aspect of consideration is the pre-existing duty rule. Remember I said there must be sufficient consideration. Although the court does not look into the adequacy, they look into the sufficiency. So the consideration cannot be a pre-existing duty. It's what we call the pre-existing duty rule. An act that is promised or performed as consideration must be something the person otherwise is not obligated to do. For example, if I say to you, I will pay you $1,000 if you stop trespassing across my yard, my driveway, that would not be an enforceable promise. Why? You have a pre-existing duty not to trespass across my yard. So there is no good consideration to support that promise. Another tricky question often comes up on the bar examination is payment of a debt with a lesser amount. If a creditor promises a full discharge and you as the person owing the obligation promise to pay less, The creditor can take your money. They can take your money and then they can sue you for the balance. Why? You have a pre-existing duty to pay the full amount of the obligation. So that is something that is often tested on the bar exam. But watch for the following. There are some exceptions to that rule. If we say that the payment of a debt with a lesser amount is not consideration, if there is a change in the terms of the obligation, then there is consideration. As long as something new is promised, if something is changed, for example, let's pretend that I owe you $1,000. And I go to you and I say to you, I cannot pay you the $1,000. Would you take $500? You say, sure, I'll take the $500. Well, if I pay you the $500, I've already told you you can still sue me for the additional $500 because I had a pre-existing duty to pay you $1,000. But pretending that I know the law of contracts very well, and I hope that's not too much of a stretch, I say to you, the obligation is due on March the 1st. And if you'll take the $500, I will pay you early. I will pay you on February the 1st. In that case, we do, in fact, have good consideration to support the promise. Why? I'm paying you a month early. I'm doing something that I didn't have to do. So that is the consideration to support our modification, if you will. Another time this is often tested on the bar examination is when there is a good faith dispute about the amount of the indebtedness. For example, pretend the Mass Electric Company sends me a bill, once again for $1,000 for my electricity for the month of February. Well, I know it was cold, but I also know my whole lifetime I've never paid more than $80 for the month of February for my fuel bill. So I know there's a mistake. And we hassle back and forth, and finally I go to Mass Electric. I don't want to hire an attorney. I know it will cost me too much money. So I say to the Mass Electric Company, I will pay you $400. And we're having a good faith dispute. I send them a letter, I send them a check for $400, and I say, this is in full satisfaction of the debt. Well, because we have a dispute over what the amount of the bill is, if they agree to take that, then that is, in fact, sufficient consideration. Next topic, modifications of existing contracts. I've already said that new consideration needs to be furnished to modify a contract. If, for example, I ask you to build me a house for $150,000 and halfway through you decide you want $175,000. And I say to you, okay, I'll pay you the $175,000 because I feel I have no other choice. So you complete my house and now you're looking for your $175,000. Guess what? I don't have to pay you $175,000. I know I said I would, but I don't have to because there was no valid modification. We had entered an agreement that you would do it for me for $150,000. So just because you want $175,000 and just because I say okay, I got a gun to my head really because I need to move into my new home, assume, then you're out of luck. I can say okay, but I can back out of my word because you had a pre-existing duty to complete my house for $150,000. So remember, there has to be new consideration to support a modification. However, there are a lot of exceptions to that rule. And by the way, these exceptions are often tested on the bar examination. For example, some jurisdictions and some courts in modification cases, the courts will avoid this pre-existing duty rule and enforce the modification on one of the following grounds. Number one, they will say the old contract has been rescinded and the parties have now formed a new contract. Or they might suggest that something different was promised or done. Maybe the agreement was you would complete my house for $175,000, but once again, you would do it 30 days early. Court might find that something different was promised, or maybe you said you'll put on a sun porch in addition for the $25,000. Now we've got something new promised. Also, in cases of unforeseen hardship. For example, assume you're building me the house, and all of a sudden you discover a big ledge of granite under there. And you know you're going to lose money if you complete my house for $150,000. Well, if it's an unforeseen hardship and I voluntarily agree to it, and it's a fair and equitable modification, the court may uphold it. Some courts will find a modification should be enforced because a party always has the ability to breach the contract, and the giving up of the power to breach the contract is, in fact, the consideration to support the modification. So those are some key exceptions. Let me tell you about the UCC. It's listed as number 5. The Uniform Commercial Code, and I need to stop here for a moment and I need to introduce you to the UCC. The UCC governs sales or transactions in goods. So if we are dealing with a contract for a good being a movable object, then we need to look to a more recent uniform statutory law, and that's called the Uniform Commercial Code. Well, the Uniform Commercial Code at 2209 eliminates the requirement for new consideration. The only requirement the UCC imposes is that of good faith. So if the contract is for the sale of goods, then if there is an attempted modification on that contract, no new consideration is needed, only good faith. Let's take a look at the bargain aspect of consideration. We said that a contract requires two things. It requires legal detriment and it requires bargain. Let's talk for just a moment about the bargain aspect of consideration. What do we mean by that? The performance or the return promise has to be bargained for. There has to be to and fro, bargaining, the bargaining process. So the court will take a look at, was it truly bargained for? Now contrast that in your mind with a situation in which something is gifted. That's not a bargain, it's a gift. There is no to and fro. So the court concerns itself with the bargain aspect of consideration. Now, before I go further and we take a look at some of the substitutes for consideration, a couple things I'd like to talk with you about. One is output requirement contracts under the UCC. There are certain types of contracts that are referred to as output contracts or requirement contracts. For example, assume I'm going to build a bridge and I need to extract sand to build this bridge. I might enter into a contract with you whereby I'm going to purchase all the sand that I can take off of your property, all of the contracts. So I am getting all of the sand that your certain piece of or parcel of land holds. For you, that's an output contract. You're giving me all of your output. And I am, in fact, taking that. That's a contract, what is called an output contract on your side. A promise to purchase all a buyer's requirements for particular goods for or from a particular seller is called a requirements contract. And on the other hand, a promise by a seller to sell his entire output, for example, of widgets, to a particular buyer is called an output contract. These are enforceable under 2206 of the UCC. The consideration that supports these particular contracts is the buyer's implicit promise not to buy elsewhere, and the seller's, on the other hand, implicit promise not to sell elsewhere. So those are output and requirements contracts. Now, sometimes another thing I'd like to tell you about is the courts might imply a promise. In some situations, there is no formal contract between two parties. In a leading case, there was a woman of notable importance throughout the country. She was some type of fashion designer. I can't recall her name. She entered into an agreement with an agent whereby he was going to put basically her label on certain merchandise. And he was going to have an exclusive right to do this. He was going to market her designs. Now, the agreement did not specify any obligations on the agent's part. So when the dress designer tried to back out of the agreement. The court said, no, you're not. We're going to imply a promise on the part of the agent to use his best efforts to market your designs, and therefore we'll find consideration. So the name of the case is Wood versus Lucy, and Lady Duff Gordon, I think, was the name. So watch for that case. It's an interesting twist on what you've been studying. There's also another thing I need to tell you about, and that's forbearance from suing on a claim. A promise not to prosecute or not to sue somebody is enforceable. It will, in fact, be consideration. Now, that's pretty simple to understand, but the difficulty arises when the claim itself becomes invalid. One of the cases we study in my textbook is FEIGE. F-E-I-G-E is the name of the case. And it's a situation where this woman is pregnant, and she believes a certain man is the father. So she goes to him and she says, I will not sue you in bastardy proceedings if, in fact, you'll pay me a certain amount of money each month. And he agrees to do this. And he starts, I think, to make the payments and then realizes, in fact, he's not the father. And so his argument is there was not good consideration to support the promise. Her saying she won't sue me is worthless because I'm not truly the father. The court said, no, doesn't matter. At the time you two entered into that contract, she honestly believed that you were the father, and therefore it is a good promise. Just because it turns out afterwards not to be a valid claim doesn't matter, as long as there was an honest belief at the time it was asserted that, in fact, it was true. So the policy reason behind this, think about it, is that the law does favor compromises. We have a backlog in the courts in which, if people can work out their differences, the law wants to encourage that. One last thing on this topic, that is recitals of consideration. Oftentimes when you're reviewing a contract, you will see an opening line that says, for good and other valuable consideration. So parties will point to that language. No consideration past tense. There was really no consideration, although in writing they say, quote, for good and other valuable consideration, or some variation of that. And they point to that language and say, hey, there is consideration because we said for good and other valuable consideration. Well, let me tell you how the courts treat that. That language is evidence that consideration was paid. It is not per se consideration. So the parties can go in and they can challenge whether the consideration was in fact ever paid. So just because you say for good and other valuable consideration doesn't make it consideration. Just reciting the words is not consideration. Consideration still must pass hands. Okay, just let me remind you of a couple of things. Nominal consideration is not consideration. I told you earlier that the court does not look into the adequacy of consideration, only the sufficiency. Now, nominal consideration is not sufficient consideration. Again, if I sell you my watch for $1,000 and my watch is a Rolex that's worth $15,000, the court might say, hey, that's nominal. Maybe I was really trying to just disguise a gift to you, and that accordingly would not be sufficient consideration. You know, fathers and mothers often do this with their children. They sell them their house, their car, or so forth for $1. Well, it's really a gift. Past consideration is not good consideration. If something happened in the past, it cannot be consideration for a present promise. Now, this is the traditional view. And the reason this is so is because the bargain aspect of consideration I talked about earlier is missing. If it's past consideration, it's not bargained for because it already happened. But there's a few states that have an interesting twist on this. They say, if the promisor receives a material benefit and makes a promise, then even though the consideration was in the past, it will be enforceable. The case, and it's a minority case, but it's known as Webb v. McGowan. Webb v. McGowan. And in this situation, what had happened is a guy is up in the rafters and he is, throwing down some sheets of wood or something of the sort. And all of a sudden, a plank is going down, and he looks underneath, and lo and behold, the boss is down there. What's he going to do? So he jumps on the plank, and he dives down with it, and he steers it so it doesn't kill his boss. Trouble is, he ends up in a wheelchair. He's crippled for life. And the promisor is so grateful, the boss, he's so grateful. He said, "Thank you for saving my life, and I'll pay you $100 a month," or some amount of money. And he does do that. And then when he expires, his family is not so grateful that he's still alive, and they tell the crippled employee, "We're not paying you anymore. There was never any consideration to support your promise," because in fact that was past consideration. And the court said, "Nope, we're carving out an exception. We're saying when the boss, the injured, when the situation happened, the boss was so grateful, he received a material benefit, and he made this promise to pay the gentleman for the rest of his life. We're going to uphold that." And once again, that's a minority opinion. The restatement second at paragraph 86, and the restatement, just in case you don't know, is a body of law that the court often, as a secondary reference, looks to. At paragraph 86, they recognize such promises as binding to the extent, quote, "necessary to prevent injustice." These cases do not arise often, but there are something that the courts do occasionally encounter. Okay. That wraps up our discussion on consideration. Before we go on to our next topic, I do want to talk with you about substitutes for consideration. We said that consideration is a necessary aspect of contracts. And so if you don't find consideration, you will not generally find an enforceable promise. However, there are some substitutes for consideration that you need to know about. So the court must either find consideration to support the promise or one of these substitutes to enforce the promise. Okay, number one. Substitute number one is reliance. It's also called promissory estoppel. It is, once again, a substitute for consideration. You can enforce the promise without consideration. Here is your definition. A promise which the promisor should reasonably expect to induce action or forbearance on the part of the promisee or the third party, and which does induce action or forbearance, is binding if injustice can only be avoided by enforcing the contract or the promise. Since legal detriment is required, the basic theory of promissory estoppel is a substitute. You substitute the reliance for the consideration or for the bargain. That's the difference between the two. Initially, this doctrine arose in charitable contribution cases. What happened is people would promise their local hospital or their favorite charity a certain amount of money. And the hospital or the charity would rely on that promise, and they'd go out and build the wing. And then they'd look to the person who made the promise of the contribution and say, "I need my money." And the promisor would say, "No, there was no consideration. It was merely a gift, and I've changed my mind." Well, that's true. There was no consideration. There was no consideration to support the promise. But it would be unjust to let the hospital have a wing and have someone come in and foreclose because the donor backed out of their promise. So the courts began this doctrine called promissory estoppel, and they substitute the reliance for the consideration and make the promise binding to the extent necessary to avoid injustice. Now note that I said the promise is enforceable to the extent necessary to avoid an injustice. We don't enforce the contract. We don't enforce the bargain, only to the extent necessary to prevent an injustice. From the charitable contribution cases, this doctrine went to the subcontractor-contractor situation. What would happen is subcontractors would put in bids to general contractors. The general contractors would rely on those bids, and they would submit an overall master sheet to bid on a project. And sometimes they would be awarded the bid, and then they'd go back to the subcontractor wanting them to honor honor their subcontractor bid, and the subcontractor would back out and say, hey, there was no consideration, there was no bargaining, and it was really very unjust because now you've got general contractors who have the job based on a price from the subcontractor. So the courts next extended this doctrine to the subcontractor, general contractor situation, and it's gone on from there. So once again, substitute for consideration. Another substitute for consideration is unjust enrichment. If a party is unjustly enriched as a result of the other side, then the court might then, on a basis of unjust enrichment, award damages. And finally, this is not as commonplace today, but at one time, contracts under seal, if they were under seal, and this was at common law, the seal served as a substitute for the consideration. So those are your substitutes for consideration. So once again, you must find either consideration or one of these substitutes to enforce the promise. Okay, that wraps up our discussion on consideration. I next want to talk with you about the statute of frauds. What is the statute of frauds all about? Well, the statute of frauds, interestingly enough, is a name for when do you need a writing? What contracts have to be in writing? When I was a law student, I thought that all contracts to be enforceable had to be in writing, and that's not true. Only certain types of contracts must be in writing. Of course, you've got proof issues if you have oral contracts, but not all contracts require a writing. So let me introduce you to those types of contracts that require a writing, and then I'll explain them further. The first one, contracts for the sale of land. Contracts for the sale of land must be in writing. Number two, contracts in consideration of marriages must be in writing. A contract in consideration of marriages must be in writing. Thirdly, contracts that cannot be performed within a year of their making must be in writing. Fourth, suretyships contracts. Contracts of sureties must be in writing. A very similar, number five, promises by an executor or an administrator to answer personally for the debt of a decedent must be in writing. And lastly, if it's a contract for the sale of goods of $500 or more, a writing is required. For students, what I have found through the years of teaching contracts, and I've been doing it now a decade, what I have found students struggle with is the terminology. Textbooks, no matter which textbook you're using, probably talks about contracts that are within the statute. What does that mean? If a contract is within the statute. If a contract is within the statute, it simply means you need a writing. If it's outside the statute, then no writing is required. So remember that basic rule, and now let's take a further look at some of these writing requirements. And one other thing before I go. When I say that a contract must be in writing if it fits within one of those 6 criteria I talked about, if there is no writing, there still may be a remedy. We still might look at restitution or, in certain scenarios, part performance. Actions in reliance certainly might help take you outside the statute of fraud requirement. Okay, now let's dispense with some of the easier ones first. Let's go down to what I referred to as number 5, promises by executors or administrators to answer personally for the debt of a decedent. If you are charged with being an executrator or an executrix of a will, and you make a decision you are personally going to answer for the debt or the duty of a decedent, you need to put that in writing if you want it to be an enforceable promise. That's pretty simple. Doesn't happen often. These rules really go back to, I don't know, the late 1800s. Some of them were swept over from England. Okay, next easy one. Suretyship contracts, contracts of suretyship. When one party promises to back up or to answer for the debt of somebody else or the duty of somebody else, that needs to be in writing. That's the general rule. So if you decide to co-sign for your sister, your child, on a loan, you're going to stand in as a surety, you need to put that in writing. Now, it's interesting. There's a main exception to this. It's what's called the main purpose rule. The main purpose rule. If the surety, although they say they're a surety, are really backing up this obligation for their own benefit, then that will take it outside the statute of frauds, meaning we don't need a writing. Let me give you an example of that. Let's assume, and this is a wild assumption, but it's good for my ego. Let's assume I'm the only person in Massachusetts that could finish this contracts lecture. And all of a sudden, during a break, I go to get a cup of coffee, and I tumble down the stairs. And there I lie. And the producer is worried because he can't get anybody else in, and this has to be completed. So he rushes me to the hospital. And when he brings me to the emergency room, he says to the attending doctor, if Diane does not pay her bill with the hospital, I will. Just get her fixed in the next hour so she can get back and finish. Well, assume I don't pay my bill. And now the hospital is looking to the director to pay the bill. Well, the director might say, you cannot enforce my promise. It had to be in writing because I was a surety. I said, if Diane doesn't pay, I will. So I'm a surety, that had to be in writing. I only said it orally, so it's not enforceable. Well, the hospital might try to argue that the reason the director made this promise was for his own benefit. And if that is the case, if the court finds that to be true, then it takes it out of the writing requirement. So the main exception to suretyship contracts is the main purpose rule. Let's continue on. Contracts in consideration of marriage. Now, I am not talking about where a man and woman fall in love and they decide to get married. You have to put that in writing. That's not what we're talking about. Think of this. If I say to you, marry me and I'll give you the moon. The giving of the moon has to be in writing. That is what we call a contract in consideration of marriage. So our mutual promises to marry need not be in writing. However, if I'm making a promise to give you the moon or to give you my vet and so forth, then that has to be in writing. So that's pretty simple also. Another fairly easy one is contracts related to an interest in land. Contracts surrounding land as a general proposition need to be in writing. The reason for that, if you're interested, is land was so valuable in earlier times that we said these contracts are of such great importance, they require a writing. Now, the key exception is licenses. Licenses do not require a writing. There are special rules also about real estate broker contracts and part performance, but we'll leave those to later on. All right, a more difficult writing requirement is contracts that cannot be performed within a year of their making. It's called the one-year provision of the statute of frauds. Any contract, as a basic rule, that cannot be performed within a year has to be in writing. Why? Because memories grow stale. So we need to have a writing to support the contract. The interesting twist in this, I think of it this way. When we say a contract that cannot be performed within a year, there must be no possibility that it can be performed within a year. No possibility at all. For example, if I say to you, I will hire you after you pass the bar, just kidding, for life. I will hire you for life. Can that be performed within a year? Maybe. You might not make it for a year. So there's a possibility you're going to die, as sad as that is. That does not have to be in writing in many jurisdictions. Why? Because there's a possibility that it can be performed within a year. On the other hand, if I hire you for 10 years, that has to be in writing. There's no possibility that you can complete a contract for 10 years within 1 year. So it must be in writing. Any contract that cannot be performed within a year of its making must be in writing. So if I hire you, for example, for 10 years, you need a writing. You need to have that in writing for my promise to be enforceable. On the other hand, if I hire you for life, because there's a possibility it will be completely performed in a year, if you die, then in fact that does not have to be in writing. Sound far-fetched? It does to me too, but these are the rules that you need to master. So that's probably the most difficult a part of the statute of frauds. Now, the last type of contract that needs to be in writing is a contract for the sale of goods $500 or more. That requires a writing. $500 or more. Not $501, but $500. So that will be tested on the bar exam. You can rest assured on that. There are, though, some very key exceptions that we need to go over. Exceptions to the sale of goods for $500 or more can be categorized the following way. Part payment. If part payment has occurred, then the statute of frauds is overtaking, or the contract comes outside of the statute of frauds upon part payment. Receipt and acceptance of the goods is another exception to the writing requirement under the UCC. If the goods have been received and accepted, you cannot then complain that you don't have a writing. If a party admits to the contract in a court proceeding, in a pleading and so forth, that would be an exception to the statute of frauds. If a party, once again, admits to the contract in a pleading, in court testimony, or the like, then the contract has been admitted to. The party cannot then deny the contract because there is no writing. Now, another major exception is specially manufactured goods. That is a very key exception to the writing requirement under the UCC, where goods are specially manufactured for a particular buyer. It would be wrong, it would not be fair for that buyer to then come in and say, hey, you don't have it in writing, because the seller isn't going to be able to sell that elsewhere. So specially manufactured goods that are not suitable for resale elsewhere are not going to be denied because there is no writing. So specially manufactured goods are an exception to the statute of frauds. Now, the statute of frauds, the one part of it is you need to memorize what contracts have to be in writing. I can tell you right now, I will test you in some way at the end of the semester on that particular issue. And the bar examiners will also test you during the bar examination on statute of frauds contracts. That's half of the equation. You need to know what contracts have to be in writing. You need to know the key exceptions that I talked to you about. Once you master that, if you decide that a writing is required, that the contract is, quote, within the statute of frauds, you need to make sure that you have a sufficient writing to satisfy the statute of frauds. So let's take a look now at the memo requirements to the statute of frauds. First off, you need a writing signed by the party to be charged containing the essential terms of the deal. If it is a contract for the sale of goods under the UCC, you need to indicate a contract has been made, identify the parties to the contract, specify the quantity, because it's not going to be enforceable beyond the quantity stated. And it needs to be, quote, signed by the party to be charged. And what that means is it has to be signed by the party against whom the contract is being enforced. So those are your memo requirements under the statute of frauds. So let me recap. Think about if you have an issue on a writing requirement, think about what contracts need to be in writing, and then from there decide, do you have a sufficient writing to satisfy the statute of frauds? Now, some ways you can get tricked is let's assume that you have a writing, or you have several writings, and it's missing some of the things that are required. For example, doesn't have the essential terms and so forth, or it's signed in one place. On a separate writing, there is no signature. The question becomes, can you tack those pieces of paper together to satisfy the sufficient writing of the UCC or sufficient writing in common law contracts? And the answer in most courts today, in a majority of jurisdictions, is yes, you can. You know, they have to relate to each other. You have to be able to really tack them together in a manner which shows that they were made at the same time and so forth. But yes, generally speaking, you can tack together several writings to make up a sufficient writing. Another tricky question is, and this is hard to understand, is there's a writing requirement, but there's no requirement that that writing have ever been delivered. It had to been made up, but there is no delivery requirement. So it can be locked away in a safe. The other side may have never seen it. However, as long as it satisfies the requirements of a writing, it will be a sufficient writing under the UCC or in common law contracts because there is no delivery requirement. Okay, let us now begin our discussion of manifestation of assent, meeting of the minds, as it is commonly called. This is offer and acceptance under the UCC. When we talk about manifestation of assent, we are talking about a meeting of the minds. It is the objective meeting that we care about, not subjectively what people are thinking. The manifestation of assent is made by written or spoken words, by acts, or by the failure to act. It is not subjectively what we feel. So the mutual assent that we talked about is an objective standard. Now, let's go back to the slide we had up a moment ago, and that starts us up with the topic of offer. Offer is your first part to the meeting of the minds, or the manifestation of assent. Let me give you my definition of an offer. An offer is a communication of a promise coupled with that which is expected in return and an intent to incur a legal obligation. The basic test of whether we have an offer is, would the recipient reasonably believe the offeror intended to give him or her the power to conclude the contract? That is your basic definition of an offer. Once again, a communication of a promise coupled with that which is expected in return and an intent to incur a legal obligation. Memorize it. Have a definition of an offer. Okay, now, when you are assessing whether you have an offer, you have to contrast that with, do you really have a solicitation for an offer or a mere inquiry? Sometimes you receive something in the mail, for example, and it has the word quote on it. I quote you a price. Is that an offer? Is that a valid offer? Well, let's talk about the word quote. If something says it's a quote, that's generally what it is. The use of the word quote is usually indicative that the party intended a quote, but it's not dispositive. It is evidence of what the parties intended. If they use the word quote on the one hand, then chances are it's a quote. If they use the word offer on the other hand, it is most likely an offer. However, that's not dispositive. The use of one word or the other is not controlling. You've got to look at the whole thing to see what was truly intended. So, for example, very famous case that I talk about in class uses the word quote. It says, quote, we quote you Mason fruit jars. Pints are $4.50, $5 a quart. Half gallons are $6.50 for immediate acceptance and shipment no later than a certain date. Is that a quote? Is that an offer? Well, it says quote, so that must mean it's a quote, right? Not what the court said. The name of this case, let me get it for you. The name of the case is Fairmont Glass Works versus Cruden Martin Woodenware Company. We're talking about the Fairmont Glass case. And once again, it says, we quote you Mason fruit jars for $4.50. Is that a quote? Court said, no, it's not a quote. And the reason is because the offer was with considerable detail. And take a look at the language. For immediate acceptance, shipment no later than a certain date. It was very promissory in nature. So the court looked at the word quote and said, that's not really what the parties intended. The party really intended to make an offer, and we're going to call it an offer because of the language for immediate acceptance, and that it came in response. In the facts, it came in response to an inquiry by the other side. So you have to look at all of the surrounding circumstances to decide whether you really have an offer or merely a quote or a solicitation for an offer. Always remember, the more definite the communication, the more likely the court is going to find that it did rise to the level of being an offer. If I say to you, for example, I have some widgets for sale. It's a mere invitation. Let's put up on the board another one. I want to sell you my Saab convertible. Are you interested? As it snows outside, I'll tell you, I'm probably about ready to sell it. Is that an offer? Nah. That's just a solicitation for an offer. That doesn't rise to the level of an offer. Okay, so as a general rule, the more definite the communication, the more likely the court is going to find it to be an offer. Now, let me also talk with you for a moment about the UCC. 2204 of the UCC basically can be construed to say the following. The parties can leave open terms, and the UCC will still find a contract. You don't need it to be as definite as you did at common law. So 2204 subsection 3, even if terms are left open for the sale of goods, as long as the parties intended to make a contract and there is a basis to provide a remedy, the court is more likely to find there to be a contract. And we'll take a look at this more in a minute. Now, what about the situation in which I decide that I want to sell my house? And I decide the best way to probably sell it is to check with my neighbors. So I write up a form letter, and I address it to a number of people. And I say, dear neighbors, I am extending an offer to sell my house to you for $160,000. Now, I've used the word offer, right? I am offering to sell you. But I say at the top of the letter, dear neighbors. How many houses do I have? I only have one. So the recipient of that should see, hey, this is just really a solicitation for an offer. She sent it out to a number of people. How do I know that? Because it says dear neighbors. So the court's more likely to find that to be a solicitation for an offer as opposed to an offer. However, just because I have only one piece of property, I could make a valid offer to a number of people, and then I would be liable to everybody who accepted. I'd have to pay money damages. So you have to be careful. Some people say, well, she only has one house, so she can only extend a valid offer to one person. I wish that were so. It isn't the case. So be careful. You know, if I took my computer and designed a custom designed letter to all of my neighbors, each individually, and I say their name, dear Mr. Smith, I am extending an offer for you to sell my house, and I give considerable detail and an expiration date, the court's likely going to find that to be an offer, and that will be problematic if I've extended that same type of an offer to many, many people. Okay. Now, let's talk about advertisements. We all sit down on Sunday, or most of us do, with a paper, and we look at advertisements. The question becomes, are advertisements offers? General rule, no. Usually an advertisement is not an offer. Rather, it's an invitation to make an offer. So when you see it in the paper, it's merely an invitation for you to go into the store to make an offer. But that's not always the case. There are exceptions to that rule. One of the exceptions is If the offer is, if the advertisement is clear, definite, specific, and promissory in nature, then the court is likely to say that that advertisement rose to the level of an offer. So as a general rule, advertisements are not offers, they're merely solicitations for offers. However, if they are clear, definite, specific, and promissory in nature, the court might find that to rise to the level of an offer. You know, one of the leading cases surrounds a fur coat and some Lapin stoles and so forth, in which it appears in the paper. And they have a house rule that it's only supposed to be available to women, but so forth. The advertisement says something to the nature of, you know, we have one fur coat worth X amount of dollars. We'll sell for $129. I'm making the money. First come, first served. And the court took a look at parts of the ad and found it to be, in part, an offer. Why? Because it was promissory in nature, it was in considerable detail, and the court said it rose to the level of being an offer, although not all parts of it were, in fact, an offer. A common example of an advertisement that is an offer is a reward. Excuse me. A reward is typically an offer, believe it or not. So when you see a reward offer in the newspaper, most likely it will be an offer, and you will have a reasonable time to go out and capture or find the missing cat and claim your reward. Another thing I ought to mention is an auction. An auction is generally one of two types. It is either without reserve or with reserve. So there are two types of auctions in which the auctioneer is seeking, bids from recipients. When he calls for a bid, the good cannot be withdrawn unless there is no bid within a reasonable period of time. So that is an auction without reserve, and therefore the holding up of the object is the offer, and the bid is the acceptance. Now, a bidder may always withdraw his bid until the auctioneer announces the completion of the sale, even if it is done without reserve. And such a retraction does not in any way revive the previous bid. So that's something that you can expect to see on a bar exam, not likely to see, however, on one of my examination questions. Now, let's talk about statements made in anger or in jest. Statements that are made in anger or jest are usually not offers. You ought to be able to see, if I say to you, I'll sell you my darn car for $5, I've had it. It doesn't go well in the snow. I'm saying that in anger or in jest. It's not really a valid offer. Let's talk about termination of offers. How long do offers last? How long do you have to accept the offer? Termination of offers. An offer will terminate at the time specified in the offer. So if I say in my offer, this offer expires in 5 days, or this offer expires on December the 30th, that's when it expires. If it says this offer will expire on December 30th, the offer is over on December the 30th. That's pretty easy, right? Well, what if no time is specified in the offer? Well, then the offer expires at a reasonable period of time. So you say to me, what's reasonable? Well, if I'm offering to sell you my watch face to face, the offer expires when the conversation ends. So we say in face-to-face conversations, the offer lasts as long as we're conversing face-to-face. If we're on the telephone, as long as the conversation lasts. By mail, it's midnight on the day that the offer is received. You've got to accept it by midnight on that day, as a general rule, and that's not without exception. And for rewards, a reasonable period of time is the time necessary to capture and convict the criminal. Another time an offer terminates is when it is rejected by the offeree. Of course, it is not effective until it's brought to the attention of the offeror. So once again, if I say to you, I will sell you my watch for $50, and you say, I don't accept, but I will pay $40, you have rejected my offer for $50. That offer is off the table. It is over. And if you say to me, I don't accept it for $50, but I will buy it for $40, and I say, no, you can't say, okay, I changed my mind, I'll take it for $50. The offer is off the table because you've rejected it. Also, a counteroffer, same thing. I offer to sell you my watch for $50. You say, I accept, but I'll only pay $30. That's a counteroffer. We label that a counteroffer. Number 5, an offer can be revoked any time as a general rule. It can be revoked by the offeror at any time. It is effective. The revocation is effective at the time it is received by the offeree. Example, I offer by mail to sell you my hat. I later mail you a revocation of my offer. A contract would be formed if you accept my offer after receiving the offer, but before you received my revocation. So if I send you an offer to buy my hat, you receive that, you say I accept, and then you receive my revocation. Too late. You have already accepted. You have a valid contract. We also can have something called an indirect revocation. If the offeree becomes aware that the offeror no longer wishes to enter the contract with the offeree, it has been revoked in an indirect fashion. We call that an indirect revocation. So that's something to pay attention to. Now, an example of that might be, I offer to sell you, I enter into a binding offer to sell you my house for $175,000. You have not accepted. And you hear through the grapevine that I sold my house to Harry. Well, guess what? It's been revoked indirectly. That's indirect revocation. You have heard that I have sold it to somebody else. So you should know that my offer is off the table to you. It's been revoked. That's an example of an indirect revocation. Now, we said that offers are generally revocable at any time by the offeror. But there is something called an irrevocable offer. There are, in certain situations, offers that are irrevocable. Let me talk with you about them. 3 situations. Let's put them up on the screen for you. If I have made an enforceable promise to you not to revoke my offer, it's called an option contract, and the offer is irrevocable. So if the offeror promises to keep the offer open for a specified period of time, and if the offeree has paid consideration to keep that offer open, the offer is irrevocable during the time that was agreed to. Another example of an irrevocable offer is where the offeree has begun performance. It's the part performance doctrine. So if the offeree has begun to perform, as opposed to mere preparation, they have begun part performance, and the offer may be irrevocable. Thirdly, under the UCC, there is what is called the firm offer rule. Under the UCC, if there is an assurance in writing that the offer will be kept open, and if the offeror is a merchant, then in fact, that offer is irrevocable. The period of irrevocability cannot exceed 90 days. No consideration is necessary to support this promise. This is a special exception under the UCC. Rejections. If the offeree rejects an offer, and a rejection is not effective until it is brought to the attention of the offeror. So because that's the case, when a rejection is sent by mail, oftentimes the offeree can overtake that rejection by calling up the offeror and saying, I accept. So my point is to remind you, a rejection is not effective until it is brought to the attention of the offeror. So once again, when a rejection is sent by mail, the offeree can still overtake the rejection and accept by a telephone call. Acceptance is the assent by the offeree to the proposal that has been made by the offeror. Once again, it is assent by the offeree to the deal that is on the table. Now, there are what I call 4 key elements to acceptance. First one, and then I'll explain them in further detail. It must be the party to whom the offer was made. The offeree can accept, nobody else. Number 2, it must be the terms of the offer. The acceptance must be in the terms of the offer. Thirdly, the offeree must know about the offer to accept it. And fourth, it must be communicated. Now, let's talk about them in greater detail. I said that, number 1, it must be the party to whom the offer was made. So, if I make an offer to you, you cannot have your mother, your sister, your father accept the offer. It has to be to whom the party was made. When there are several offerees in the offer, it is what's called typically a general offer. And as long as you are a member of the party to whom the offer was extended, the general public, then you can go ahead and accept. Let me tell you, options are transferable. So if you and I enter into an option contract, you can then transfer that option to somebody else. And it would be appropriate for that other party to accept the offer. Okay, the second element that I said has to be present for there to be a valid acceptance is it must be in the terms of the offer. We say that the offeror is the master of the offer. They can set up the offer any way they want. That's the rule. The acceptance must be in the terms of the offer. If you want to enter into the contract, you have to accept in the terms that the offeror has set up. This means that the acceptance cannot vary the terms of the offer. It has to be a mirror image to the offer. Unilateral offers, and I'm going to tell you about unilateral offers in a minute. Unilateral offers must be accepted by doing the act. If I say to you, I will pay you $10 to run the Boston Marathon, you must run the Boston Marathon. Bilateral contracts, on the other hand, are a promise for a promise, which means you have mutual promises. Unilateral contracts is a promise for an act. I promise to pay you money, you do an act, you run the marathon, would be an example. And thirdly, if the offeror specifies any particular means of acceptance, this must be followed. If I send you an offer by carrier pigeon, and I say, you must reply by carrier pigeon. You know what? You got to reply by carrier pigeon. I'm the master. I can set up the deal any way I want it to be. Traditional contract law takes the position that any change in the terms of an offer made by the offeror to the offeree, if the offeree attempts to change them in an acceptance, then there can be no contract formation. Now, let me talk a moment again about the difference between bilateral and unilateral contracts. Generally, when an offer calls for a promise, it can only be accepted by returning the promise. It's called bilateral because upon formation, both parties are making mutual promises, and they are bound by those promises. When an offer calls for an act, the doing of the act constitutes the acceptance. The contract is not formed as a general rule until that act is performed. So these are called unilateral contracts. And be clear on the difference between the two. Now, the third element of acceptance is that the offeree must know about the offer to accept it. If the offer requires knowledge at the time of acceptance, then the offeree has to know about it. But what about the case in which the offeree begins to perform, they don't know about the offer, and then they find out before they complete acceptance? As a general rule, that would be then a valid acceptance. Arises most often in the situation of a reward. For example, assume I'm out running tonight, and all of a sudden I see a guy coming out of the bank. It's midnight, so I know the bank's not open. He's got a gun. And I somehow run up and jump him, and I capture him, and I haul him up to the police station, tie him up, put him in my car, we get to the police station. Now, I don't know there's a reward out for this guy, but there is. If I bring him in and I turn him in, I'm not entitled to the reward, right? I didn't know about it. So we said element number 3 is you have to know of the offer to accept it. Well, let's assume, same scenario, that I've captured the guy and I'm hauling him up to the police station and I see a big sign outside the police station that says reward. Question becomes, I could let him go, right? Now I know about it. Am I entitled to it? Probably. Okay, last element of acceptance. We said it must be communicated. Let me explain to you what that means. The general rule is, if it is a unilateral contract, and to refresh your memory, a unilateral contract means a promise for an act. If it is a unilateral contract, no notice of acceptance is required except if it is unlikely that the offeror would know that the offeree is accepting. So as a general rule, where the acceptance is by performance of an act, a unilateral contract, no notification of acceptance is necessary unless the offeror requests it, or where it's unlikely the offeror is going to know that the offeree is doing the act. With respect to bilateral contracts, a promise for a promise, notice of acceptance is in fact required. Generally, the offeree must notify the offeror of the acceptance. The next question when you're studying acceptance is typically, when is acceptance effective? The majority rule in contracts is that if an acceptance is being mailed, if it is being concluded by what we call correspondence, the acceptance is effective as soon as it is put out of the possession of the offeree. This is what is known as the mailbox rule, the very famous case of Adams versus Lindsell dating back to 1818. So it's what we call the mailbox rule, and it says acceptance is effective as soon as it's put out of the possession of the offeree. Now, since the offeror is the master of the offer, they can set up rules that are different. They can vary the rules as they see fit, because the offeror, once again, is the master of the offer. Now, another question becomes, can silence be acceptance? Is silence acceptance? Typically, no. Silence cannot serve as an acceptance. You can't remain silent and say, well, I accept it. That is not the typical rule. The exceptions to that, let me go over them with you. Silence can be acceptance where the offeree takes the benefit of the offer with a reasonable belief by the offeror that that would constitute an acceptance. That would be a valid acceptance. Also, where the offeror has stated or given the offeree reason to understand that assent may be by inaction, or it may be because of previous dealings between the parties. So in those situations, silence can be acceptance. Let's talk about the means of giving notice. When contracts are concluded by correspondence, the traditional rule is that the offeree must respond in the same way the offer was made. In other words, If the offer is sent by mail, the acceptance must be by mail. The modern trend you need to know is that we have deviated from the strict rule towards a rule that says any reasonable means of communicating acceptance is valid, as long as it will get there as fast. So if I today send you an offer in the mail and you call me up on the phone, absent my stating otherwise in the offer, that would probably be, under a modern view, a reasonable means of accepting and therefore a valid acceptance. So remember, traditional rule, means of giving notice, the same way the offer is extended. The more modern trend is any reasonable means is okay.